So today we continue with our lesson on drafting of a deed of assignment. In the first part, we learned how to draft the introductory part of the deed, which comprised of 4 clauses, namely the commencement clause, the date clause, the parties clause, the recital. Now, in the second part, we have now the main body of the deed, which is also known as the operative part. Now, it begins with the clause known as the testator, all right, which simply says, now this deed witnesses as follows, all right, the testator, because it's going to bear witness to something, it's going to testify about the transaction that has taken place. Now, in this transaction for a sale of land, what has taken place is that one party known as the purchaser or assignee pays the other party known as the vendor or assignor for his land, and in return, the vendor transfers his legal interest to the person, all right? And that's why the next clause we have is the consideration clause, all right? Because there is money that is paid. Now, how is it drafted? It says, in consideration of the sum of, now in this example, we have 7 million naira used. So we have 7 million in figures and then 7 million in words already paid to the assigner by the assignee. Now, when money is paid by one party to the other, and what the other party would expect as acknowledgement of that payment is a receipt. And so the receipt clause comes next. The receipt of which the assigner acknowledges. The receipt of which the assigner acknowledges. In some drafts, they would say the receipt and sufficiency of which the assigner acknowledges. It's all fair and good. Now, one of the advantages of having a receipt clause, which is something questions could also ask you, is that if you have a receipt clause and insert it in a deed, then there is no need to issue a further receipt. Now, after the receipt has been acknowledged, the next thing is that the assigner would proceed now to transfer his legal interest to the assignee. But in order to do that, he needs to show that he is capable, he's competent. He has the right standing to do so, and that's why the next clause is the capacity clause. All right, and how is it drafted? It will read as follows: the assigner as beneficial owner. All right, so that's the capacity in which he intends to make the transfer as beneficial owner. Now, a very common question you'll find is when you're asked about the covenants that are implied into a transaction when the assigner assigns his property as beneficial owner. Now, there are 4 covenants that are implied. Now, one is that he has a good right to convey the title. 2 is that he's granting quiet enjoyment to the assignee. 3 is that the title is free from all encumbrances apart from those already disclosed. And 4, that he's granting further assurance to the assignee. So those are the 4 clauses, the 4 covenants rather, that are implied into the transaction when he's beneficial owner. Now, what comes next after that? It's the words of grant, the words by which he is granting title to the assignee. And so it's just one word, assigns, all right? Sometimes you can see it written conveys or transfers. It's all the same. So that's the words of grant. Now, what is he granting? He's granting, of course, the property to the assignee. So the next clause is called the parcel clause, because you can think about land as being a parcel, parcels of land. You can think about land that way. So the next clause is called the parcel clause, which would provide a description of that land that is being assigned or transferred in the transaction. So it will read as follows. Assigns, yes, to the assignee all that 2-story building located at 45 Gamble Street, Jos Plateau State, covered by certificate of occupancy number so-and-so, dated so-and-so, and registered as -- in the lands registry Plateau State. Now, this is how it would be drafted if the land in question is land that is already developed. You see, it provides a description there, 2-story building. If it was vacant land that is not developed yet, it would simply say all that parcel of land, and then we provide the location, as you can see here. And you can also see that apart from providing the description of the property, it also provides you with the particulars of registration of title. You can see the C of O here, the particulars of the C of O is provided. Now, of course, every time you have registered title, the three numbers that are provided as particulars of registration are symbolize the number, the page, and the volume where you can find that title registered at the land's registry. So for instance, 5959/2031 stands for number, page, and volume, where the registration would be found in the land registry of that state. So after the parcel clause, what comes next? It's the habendum. The habendum is the clause that describes the quantum of interest that is being granted to the assignee by the assigner. How much long is he granting the property to the assignee to hold it, to own it? And that's why to draft it, we'll draft it as follows: to hold onto the assignee for the term unexpired on the said right of occupancy, free of all encumbrances and subject to provisions of the Land Use Act. All right, so he grants it to the assignee to hold, not forever, not ad infinitum, but for the term unexpired, because the assignee is only acquiring the term that is left from the original term that was granted to the assigner by the governor. Of course, typically it's 99 years that the governor grants when he's granting C of O. Now let's imagine that the assigner had lived there 50 years and now he has decided to sell the property. Now what he's transferring to the assignee would be 49 years, because after 49 years expires, the assignee would need to apply to the governor again for grant of consent. So that's the term unexpired that is being granted. And so that's how the habendum is drafted, and that's the last clause in the operative part or the main body of the deed. So the clauses, again, in their logical order are as follows. You have first the testator, and then the consideration clause, and then after that, you have the receipt clause, and after that, you have the capacity clause. And next, you have the words of grant, and then you have the parcel clause, and finally, the habendum. And so I hope you have learned something today, and I'll see you again some other time. Bye-bye.